President, I thank the senator from Texas for his remarks, and I do appreciate the encouragement he's given both Senator Shelby and myself in getting the appropriations bills through. As he knows, he's been here long enough, knows this is the way the Senate should work. We've done it in a bipartisan way, and we are way ahead of where we've been at any time in the past few years. I also want to applaud the senior senator from Maine. She sits on the Appropriations Committee. We've served together there and throughout our careers, and she is a valuable member of that committee, and she is one who's helped put together with her Democratic counterpart good legislation. It's included, in fact, her committee, we were a nearly unanimous vote in the Appropriations Committee. Most of this has been either unanimous or virtually unanimous. I say it because some have felt that in the Senate, lately you could not get a majority vote even to say the sun rises in the east, but here we've been doing majority votes on things that involve everywhere from Alaska to Vermont, and I'm pleased with it. Now I would, I take the floor in my role as Vice Chairman of Appropriations and managing this bill, but I'm going to digress as others have for a few minutes and speak about something else. We're now less than 2 weeks away from Judge Kavanaugh's confirmation hearing before the Senate Judiciary Committee. 2 weeks away, and the committee has received only 6% of its total White House records, according to the National Archives. This is virtually unprecedented. 6% of his records. And not a single one of the records we've received has been provided by the National Archives. That's because the archives will not complete its review of the limited number of records requested by Chairman Grassley until October, a month after the majority leader intends to hold a final vote on Judge Kavanaugh. Actually, every single record that we have received in the Judiciary Committee to date was hand-selected by a political lawyer representing President George W. Bush. It's a partisan lawyer who reported directly to Judge Kavanaugh from the Bush White House, who also represents White House counsel Don McCann, Steve Bannon, and Reince Priebus in the Russian investigation. I mention this because he's been very selective on the very few things we've been allowed to see. Now, I mention this because this is in stark contrast to past precedent. We're talking about the vetting of Justice Kagan, who, like Judge Kavanaugh, has served in the White House prior to her nomination. I was chairman of the Judiciary Committee at that time. I worked hand in hand with ranking member Jeff Sessions to ensure we received every document of interest to the committee. And certainly Senator Sessions demanded on behalf of the Republicans an awful lot of records, and I worked with him to get them. In fact, when we were 12 days away from Justice Kagan's hearing, we had already received a full 99% of our White House records. 99%. I mention that because now at the same time on Judge Kavanaugh, we're at 6%. Republicans allow 6%, Democrats allow 99%. Does this make the confirmation hearing a partisan joke? In fact, every single one of Justice Kagan's records were provided by the nonpartisan National Archive. The 6% of Judge Kavanaugh's records were provided by a political, partisan, hyper-conflicted attorney. I mean, just on the face of it, it does not pass the giggle test. Democrats provided from the nonpartisan National Archive 99% of Justice Kagan's record. Here we're getting only 6% of Judge Kavanaugh's records, and they are picked by a political partisan attorney with hyper conflicts. And the superficial vetting of Judge Kavanaugh is all the more troubling because there's still serious concerns about the last time he testified before the Senate. During his 2006 nomination hearing for the D.C. Circuit Court of Appeals, Judge Kavanaugh minimized his work on highly controversial issues in the Bush White House, including detainee treatment and warrantless wiretapping. It's now clear that we will only know the full truth if we get his full record. Anything less is simply rushing to a verdict before the trial. Based on the very limited documents that they've allowed us to see, there's additional reason to be concerned. The committee has received new evidence that sheds light on whether Judge Kavanaugh was truthful under oath in 2006. Unfortunately, I can't even describe these documents because they've kept them in a classified or a confidential form, and the American people cannot see them. What bothers me even more is the majority of the Senate can't see them either. Majority of Republicans and Democrats in the Senate can't see them. That's because nearly 2/3 of the documents the Judiciary Committee have received have been designated as committee confidential by Chairman Grassley. That followed the request of the partisan attorney who the Senate is relying on to do the job of the nonpartisan National Archives. To date, that means that 2% of Judge Kavanaugh's White House record is available to the American people. 2%. As compared to 99% with Justice Kagan. 2%. And they select what that 2% is. Golly. What's in the other 98% that they don't want us to see? Now, I've served in this body for 44 years. I've been here for every Supreme Court nomination since John Paul Stevens. I voted for a lot of Republicans and Democrats on the Supreme Court. For 20 years, I served as the chairman or ranking member of the Senate Judiciary Committee. In those 44 years, I can tell you, frankly, the vetting of Judge Kavanaugh is the most incomplete, most partisan, and least transparent for any Supreme Court nominee of either a Democratic or Republican president I've ever seen. It's not even close. 44 years, I'm taking the experience I've had here with Democrats and Republicans as president. I have never seen such an incomplete, partisan, or least transparent vetting. Now, yesterday I met with Judge Kavanaugh, very pleasant man. I had the opportunity to ask him about many issues, including his work in the Bush White House. And following our meeting, I believe even more strongly the documents he authored or contributed to during his 3 years as the White House staff secretary should be released and made public now. What he wrote is far more important than what his personality might be. Let's find out what he wrote. That tells us what kind of a Supreme Court member he would be apt to be. You know, a vigilant review of the Supreme Court nominee's full record isn't an optional matter. It shouldn't depend upon what party controls the White House or the Senate. Again, in 44 years, I've seen very vigilant review of Supreme Court nominees by both Republicans and Democrats, and that's the way it should be. I've agreed with that every single time. But never, never, never have I seen something like this. Never, never have I seen a record hidden the way this one is. It is undeniable that documents of clear public interest are being hidden from the American people. Documents that would shed a light on both his views and his fitness to serve on our nation's highest court. Wearing blinders in this moment is fundamentally incompatible with our constitutional obligation to provide advice and informed consent. Mr. President, the United States Senate is supposed to be the conscience of the nation. It's a sad conscience. The federal judiciary stands alone. Unlike any other branch of our government, the judges, for good reason, never face the scrutiny of the electorate. Once a Supreme Court justice is confirmed, he or she serves for life. Barring impeachment, which has happened just once in our nation's history, they serve with essentially no oversight. That means the Senate has no second chance when it comes to vetting a nominee. We have to get this right now. We can't have a vote now and in 2 months from now get the record and say, oh, golly, gee, if we'd known this, we would have voted differently. We have to have all the records now and then vote. And there's time to do so. The Senate should not be focused on getting Judge Kavanaugh confirmed by October 1st in some artificial deadline. Instead, the Senate should be focused on doing its job. And that requires allowing the National Archives to complete its review of Judge Kavanaugh's record, as required by the Presidential Records Act. At a time when the President is facing unprecedented legal jeopardy, it'd be an extraordinary disservice to the American people to break all precedents, and confirm his selection to the Supreme Court without an actual review. Have the review. Then every senator, he or she, can make up their mind how they're going to vote. But don't vote blindly without all the material. The fact that Judge Kavanaugh has a longer record than prior Supreme Court nominees, something the President was keenly aware of when he selected him, does not excuse the Senate from doing its job. Because if confirmed, he's going to shape the lives of all Americans for generations to come. If when the National Archives completes its review in October, we learn that we did not get it right, it's going to fall squarely on the shoulders of this body. Every senator, if it finds out because we rushed this, if they find out later there was material there they should have seen, they will have absolutely no excuse whatsoever because they concurred in the rushing. We should set this partisan vetting aside. We should work together, as we have in the past, to actually vet Judge Kavanaugh's record in a way that honors both our constitutional obligation, the job the American people sent us here to do. Mr. President, I feel honored to be here as U.S. Senator from the state of Vermont. I do strongly believe, as I heard when I first came here, that this body can be the conscience of the nation. We're not following our conscience if we don't do the real work to find out what we're voting on. We vote on a lot of things. Some are routine. This is not. This is to voting for a person who can serve on the Supreme Court long after most of us will have left this body. We owe it to all Americans, I don't care what their politics are or where they're from, to get it right. That's what our oath calls for. That's why we're here. I've voted more than all but 3 or 4 people in the history of this country. Every time I vote, I'm hoping I'm doing it right. I hope I do, but I try to do it in an informed way. So, Mr. President, I know we're going to go back now to the appropriations bills. Here's a case where I think we have done things right. Senator Shelby is the chairman, I'm the vice chairman. It's one of only 3 committees that has a vice chairman. We've worked very, very closely together. We've done it in a way to get bills through in a bipartisan fashion. We actually worked the way the Senate did when I first came here, the way the Senate has under great leaders. On the Democratic side like Mike Mansfield, the Republican side like Howard Baker. And we've got things done. So I'm proud of the Appropriations Committee. I am concerned about the Judiciary Committee. I've had the privilege of serving on it for over 40 years, privilege of being chairman and ranking member. But I have to say, it is not doing its job. It is not requiring all the material to be here. Senator Shelby and I in the Appropriations Committee worked to make sure everybody's heard. Everybody had the material. We should be doing the same thing on the Judiciary Committee. I see the chairman of the committee on the floor, and I've spoken on the matter I want to speak on, and I will yield the floor.